Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions in today's video. If Ripple prevails in its legal fight with the U.S. Securities and Exchange Commission, SEC, the relisting of the XRP token on the main U.S. crypto exchange Coinbase will be one of the greatest headlines in the XRP ecosystem. In a recent interview, Coinbase's chief legal officer, CLO, Paul Grewal, has talked in depth about the matter and outlined how the XRP relisting process would work. Coinbase banned XRP trading in January 2021, soon after the SEC filed its complaint, and has since kept the coin suspended despite vociferous XRP community requests. Grewal stated his hope for a Ripple triumph in yesterday's discussion with Thinking Crypto presenter Tony Edward, but also highlighted that a relisting does not rely entirely on a trial court success. Grewal said that the U.S. crypto exchange assesses assets on a regular basis for listing, delisting, or halting. He also understands the XRP community's angst. I realize it has been irritating for many XRP holders that they have not been able to trade their assets on Coinbase while this SEC action has been ongoing, Grewal said, adding that the SEC has not prevented Coinbase from closely monitoring the state of the dispute. Grewal, like everyone else, is looking forward to the judgment and lauding Ripple's attorneys' efforts. I definitely paid attention to the fact that the defendants in this case have done a fantastic job of pushing the SEC and raising fundamental concerns about the SEC's overall argument. Coinbase has filed an amicus brief in favor of some of Ripple's arguments. According to Grewal, Ripple's CEO Stuart Alderety and the rest of the fintech business have done an amazing job, which is why he believes the court will rule in Ripple's favor. We'll show that the SEC ideas are flawed. I believe the briefing in this case has been outstanding, and we will all soon see what the trial judges think of the arguments. Nonetheless, the Coinbase CLO emphasized that, in his judgment, the Southern District Court of New York's ruling is merely the first stage in a prolonged process. Grewal feels that regardless matter who wins in court, both parties in the case will appeal. Grewal added that the timing for relisting following the trial court judgment relies on the reasons of the judgment, the judge's legal rationale, and Coinbase's opinion of whether or not the decision would be upheld by the appeals court. Therefore, a lot is going to rely on the particulars of that court rulings. I realize it won't be very pleasing for some, but as a publicly traded firm, we have a duty to tread cautiously in this area, and with regard to any token that's the subject of federal court action, Grewal said. Finally, the Coinbase CLO said that the exchange would begin the review process as soon as the judgment is published. So, like everyone else, I am curious to see how the court decides, and all I can say is that as soon as we obtain the verdict, we will begin our process to see if we need to reconsider our listing decision. The judgment in the legal action between Ripple and the Securities Exchange Commission, SEC, is expected by the end of March, and the cryptocurrency world is eagerly awaiting it. USC. Attorney Jeremy Hogan tweeted on March 9 that it's possible that U.S. District Court Judge Annalisa Torres has already made up her mind on whether or not XRP is a security. Hogan, a pro-XRP attorney, came to this conclusion after pointing out that the judge referred to the securities law case Marine Bank v. Weaver at least 3 times in her most recent judgment while describing the viewpoint of XRP holders who purchased the coin. Hogan included a case sample in which he cast doubt on whether or not the item in issue was commonly understood to be a security. The latest order by the court at least 3 times addressed the case of Marine Bank v. Weaver in describing what a reasonable XRP purchaser thought when they acquired the XRP issue. When Judge Torres issued a 57-page ruling on the Doe-Bear applications both parties filed to exclude expert evidence from the summary judgment, the attorney made his argument. The court approved and dismissed parts of both parties' requests, so neither Ripple nor the SEC can claim victory. Judge Torres ruled that the SEC's main expert witness, Patrick Doody, who was supposed to evaluate XRP purchasers' expectations, could not testify. On the other hand, Ripple's experts about the differences between Ripple's contracts and those in the Huawei case, the tax treatment of XRP, the accounting treatment of XRP, and currency experts on XRP and currency experts on XRP were all permitted to stay on the record. While the Doe-Bear motion's judgment was split down the middle, Ripple's chief legal officer Stuart Alderety said the company was confident in its case and that it would ultimately prevail. "We have been confident in our case from the beginning, and that confidence has only grown with each judgment, Alderodi added. Meanwhile, XRP supporter attorney John Deaton thinks the SEC made a big mistake by identifying Ripple executives Brad Garlinghouse and Chris Larson in its legal case. Deaton claims that the SEC should have investigated XRP's issue in business, Ripple, rather than going after people who aren't directly responsible for the alleged securities breaches. At first, Deaton claimed that the judge had said that SEC attorneys had put their own interests ahead of enforcing the law. The attorney expressed doubt that the SEC could enforce the law if its own employees disregarded it. According to Finbold's reporting, Scott Chamberlain, a former lawyer and co-founder of the permissionless Layer 2 platform Evernode, XRP, has predicted that the lawsuit might go one of 5 ways. Chamberlain thinks the case may end up settling, which would establish precedents about whether or not XRP and whether or not the court has jurisdiction over purchases made in other countries Ripple has already filed a letter in support of its fair notice defense, referencing a recent Supreme Court decision. The petition was submitted in reaction to a judgment that curtailed the authority of the United States government to punish citizens who failed to disclose foreign financial accounts to the IRS. Ripple highlighted the need for regulatory clarity in the cryptocurrency business by emphasizing the need of federal legislation, creating clear limits on what behaviors are illegal. According to attorney John E. Deaton, the United States Securities and Exchange Commission, SEC, action against Ripple might reach the United States Supreme Court before Congress adopts a regulatory framework for the crypto business. For perspective, the matter is now in district court and would need to be heard by the Circuit Court of Appeals before being heard by the Supreme Court. In a tweet today, the crypto law creator stated this viewpoint that followed hints that the SEC had no intentions to slow down its aggressive crypto enforcement activities. Fox business writer Eleanor Terrett published an extract from the SEC's current budget plan. Significantly, the government adds that it will not hesitate to investigate and prosecute crypto businesses that it considers non-compliant. This, according to Terrett, signals that the regulator would increase its crypto enforcement section, which has more than quadrupled in size in the last year. Citing Terrett's conclusions, Deaton reiterates that the courts will be the sole source of clarification for crypto for the next 2 years. Although he acknowledges that it is not ideal, he insists that it is the current reality. Hell, before Congress acts, the Ripple case might be heard by the Supreme Court. Deaton tweeted, "We have to battle in court." In January, Deaton said that the highly awaited verdict in the Ripple case on whether XRP is an unregistered securities would provide the embryonic market with the only clarification it would get in the next 2 years. The lawyer presented this case by highlighting the polarization of Congress and the bitter taste the FEC's failure has left in MPS's mouths. Yesterday, the attorney representing thousands of XRP investors in the SEC complaint against Ripple as a friend of the court said that Judge Annalisa Torres' approaching judgment becomes more momentous with each passing day. He did, however, express confidence that the federal court will rule that secondary market transactions of XRP are unregistered securities. There is no precedence, according to Deaton, and Judge Torres is a stickler about obeying the law. There is no way the court will accept the SEC's unlawful premise that the asset itself is always an investment contract, Deaton said on Twitter. There hasn't been a case in the 80 years since Howard that makes such a conclusion. Judge Torres strictly adheres to the law. She refuses to find that secondary sales violate Section 5. According to Deaton, the only way the SEC can win its case against Ripple is if the blockchain payments company offered XRP as a security from 2013 to 2017. Judge Torres issued her decision on Daubert requests to prohibit expert evidence last week. It was largely seen as a Ripple success, with Ripple General Counsel Stuart Alderodi claiming that the firm's confidence improves with each verdict. Deaton anticipates that the judge's decision on summary judgment will be issued shortly.